Hello, my name is Basharat Ali and I am here presenting at Auckland Solicitor in St. Albans. In this video, let me explain the key features of FOB contracts, also known as free on board contracts, a common type of international sales contract. The definition, duties of the parties, passing of risk and properties, remedies for breach, and variation of the FOB contracts I will cover. This will also include citing relevant case law and legislation to bolster the discussion. Let's begin with the basic definition of FOB contract. An international trade, an FOB contract is used when the seller is responsible for goods upon to their loading on the vessel chosen by the buyer at the agreed port of shipment. From that moment, both risk and cost transfer to the buyer. Free on board, however, is a term used because the seller actually delivers the goods free onto the ship and takes away further responsibilities. The term of the FOB contracts and the provisions of the statutory legislation of the Sales of Goods Act 1979 from the legal foundation upon which FOB contracts are based, and these contracts term and the preponderance of the example of case are developed in the case of Parani, Skindia and the Albazro. Now let's break down the duty of the seller under the FOB contracts. The seller duty is primarily to furnish goods that meet the contract as to quality, quantity. The seller also has to deliver the goods on the agreed time. The goods are loaded onto the ship at the agreed port of shipment. Following shipment of goods onto the transport vehicles, the seller needs to provide all required shipment documents to the buyer, a set of standard documents that includes a clean bill of lading for reception. Furthermore, the seller is also subject to the duties to notify the buyer that the goods have been shipped shipped in order for the buyer to plan the arrival of the goods. A leading case illustrating the seller duties in Parani Company Limited with Skindia Steam Navigation Company Limited 1954, where the risk in this case was agreed upon by the seller in arranging to load. But since the critical moment for passing risk is when the goods are loaded on board, the contract in this case is still to be considered as FOB contract. In this case, it was clarified that FOB contracts can be flexible in practice. Moving on to the duties of the buyer. The buyer will nominate a vessel capable of loading the goods in the agreed port and at the agreed time. The seller may be excused from performance if the buyer fails to nominate a fitting ship or does not hereby do so in time. When goods are on board, the buyer is responsible for paying freight and insurance when it is presented. The buyer also accepts the shipping documents and paying the practice price, contract price. In particular, it is important in relation to the risk of loss and damage to the goods as a risk thereof was transferred by the bringing the goods on board the ship, even if the goods are lost at sea. In the case of Al Bazro 1977 is relevant here. In case limited a buyer the ability to claim damages if there were not the owner of the goods at the time of loss. It highlighted the importance of understanding when property passes under a FOB contract, which is often governed by the parties' intention or feeling that by the rules in section 17 and 19 of the Sales of Goods Act 1979. This leads us to the question of when risk and properties may pass under FOB contracts. As a general rule, the risk passes to the buyer since the goods are loaded on the vessel. However, property or ownership may pass at a different times depending on what the contracts say and what can be implied under a Sales of Goods Act. It is important because while the buyer might bear the risk, they may not yet have legal title to the goods. No, let's discuss what happens if either party breaches the contract. If the goods are not delivered on time by the seller, the buyer can claim damages for non-delivery under Section 51 of the Sales of Goods Act 1979. This generally determines the level of damages in that it is the difference between the contract price and the market price at the same time the goods should have been delivered. It means that the buyer may not provide goods that conform to those in the contract term and not compensate, keep their right to compensation. However, if the buyer breaches by refusing to accept the delivery or making payment, the seller can recover damages for non-acceptance under Section 50 of the Sales of Goods Act. Furthermore, depending on the decision of the seller, he or she can choose to resell these goods with equality in the claim of the amount by which the resale value exceeds the contract price. The remedy for breach of the contract is to restore the innocent party to the position which he would have occupied if the contract had been performed. Let's also briefly consider the variation of FOB contract if they are not all identical. The typical example of the FOB contract is a strict one, whereby the buyer nominates the ship and the seller is only called upon to deliver the goods on board. No, there is an FOB contract that include extra services, that is with the seller to handle shipping or insurance for the buyer. Although in theory at the buyer expense, in the last case FOB is with the seller nomination or FOB contracts with additional obligation where the seller chooses the vessel. In this contract the version is very close to CIF contracts, but risk is passing under FOB terms at shipment. Each variation affects the timing of risk and duties. So, business using FOB terms must specify clearly in their contract who is responsible for each stage of shipping process. Thank you for watching this video. I hope this explanation of FOB contracts has been useful. If you would like further advice or have questions about FOB contracts or international trade law, feel free to contact us at Oakland Solicitor.